We can also authenticate and sign documents electronically in a very confidential and safe manner. So, that is another possibility which eliminates the need for physical paperwork altogether. Now, there are, as mediators, we know, especially if you're handling a lot of mediations at the same time or very complex mediations, there's a lot of paperwork, there are a lot of schedules, there are a lot of deadlines we have to meet. And handling all that physically can be difficult. So there are some case management systems, which help us streamline these administrative tasks. Like it can be scheduling, it can be document organization, it can be tracking our progress across different mediation sessions. It could be creating automated reminders, storing in client information, or even automated reporting capabilities, which are enabled. So some of the examples of such case management systems are ADR Notable, Access, as well as National Arbitration and Mediation, the platform. So, so all in all, we say that, there are these video conferencing platforms, there are, storage platforms, chat and messaging tools, electronic signature platforms, as well as case management systems, which can not only help you in online mediation, but also you can integrate elements of this in physical mediations as and when needed. Another part is that all of these examples that I have given today are in no way exhaustive, and I'm not endorsing them, but these are some commonly available tools that you may have. But if we do once research, we may find many, many more platforms. In fact, more and more physical mediation centers are also hosting their own websites and their own ODR online dispute resolution systems, where parties can, which parties can take to and engage in online mediation. Now, we see that there is a growth of dedicated ODR platforms. So what are these platforms? These platforms basically integrate the different tools that I mentioned in the previous two slides. They'll have video conferencing, chat, breakout room facilities, online signature possibilities, case management systems, and many of them will also even have systems for payments. So everything that you do in a physical mediation, you can do on these integrated ODR platforms. You have virtual negotiation places, scheduling tools, document management systems, all integrated end to end under one platform. So these are few examples of such dedicated ODR platforms which are available. Again, I've just mentioned very few examples, but there are many, many more. And I'll just briefly lead you through at least these 6 different types of ODR platforms and what they have to offer, in case some of you may want to use this as part of your process. So, so the first is called the Virtual Mediation Lab. Now, this is particularly created to engage in virtual mediation sessions. They have possibilities of engaging in private breakout rooms. They have the opportunity of engaging in document sharing. They have good and very privatized communication channels, and it's also conducted through Zoom. So, that's Virtual Mediation Lab for you. Modron is also another ODR platform that provides end-to-end mediation services. It helps you schedule, it helps you share documents, it helps you, engage in video conferencing. Then there's Adobe Connect, which is again a very comprehensive web-based conference platform. It gives you, again, the availability of breakout rooms, whiteboards, and even polling tools. So if you want to gauge, there are multiple parties, and if you want to gauge people's opinions on a certain option or a solution, the option of polling is also available over here. And this platform is highly customizable depending on the needs and requirements of the different parties. Then coming to immediation. In mediation, you're able to display documents, you're able to work on a virtual whiteboard, you're able to draft settlement agreements in live time along with the parties, you're able to get out into breakout rooms, so on and so forth. Then Virtual Courthouse is another ODR platform which helps in secure messaging, video conferencing, data storage, etc., and which makes it very, very flexible for a diverse range of negotiation and mediation scenarios. And last but not the least, we have Modria. In this, video conferencing is not possible, but it provides a very safe and secure environment for written communication or written negotiation. It provides for private and group conversations, but in a time-delayed written format. And mediators can also be a part of this conversation. If parties need time and they really want to, just communicate through the written mean, this provides a end-to-end solution for that as well. So like I mentioned, we've spoken about the advantages, we've spoken about the different softwares that may be, the different technological tools, and particularly as mediators, some dedicated ODR tools which are coming up, which provide end-to-end solutions and integrated platforms for everything that we can do in a physical mediation to work together on a virtual platform. So it may all seem really nice and, wow, technology is the new way to be and online mediation is the future, as a lot of developed nations are doing. But I understand what you may be thinking, that most of us belonging to Bangladesh or India, Nepal, South Asian countries, where people are just beginning to understand the nuances of mediation, where the organizations like BIMS are just trying to promote mediation. All of you are here for training. How do you expect participants and even mediators to suddenly leapfrog to such technological, elements? So, and many of you would be seeing, and of course, it's true that there are various challenges to the online mediation process as well. But at the same time, we realize that it's our role as mediators to circumvent that and best use leverage the opportunities which online mediation presents to us. So the first major challenge that we could face are the technical barriers or the digital divide that we can face with our participants or even as mediators as we navigate different complex situations. So firstly, all the participants may not have equal access to internet connectivity. And even if they do, they may not be very well versed with using technology and they will not be comfortable using these platforms. There may be differences in the level of digital literacy that these people have, or some people, including many of us, would just be resistant to change. We would feel that why don't we just go for physical mediation? And a lot of this stems from socioeconomic disparities, access to internet connectivity, access to digital literacy initiatives, etc. And most of these things can even exacerbate this divide as well. So it is our role as mediators so that we can ensure that the mediation practice is extremely inclusive and accessible to the participants that we are. And we have to make sure to make them comfortable. We need to make sure that they're well guided as to the process of online mediation. If they have any doubts with respect to what technology is being used or what the tools are being used or how to do it, one can engage in a pre-mediation session when all of these things are clarified to the participants. And you need to help them get that training, get their guidance. So our role in as mediators is not just then to conduct the mediation session, but it's also, if we are doing online mediation, to make sure that all the participants are on the same page. They are comfortable with using this technology, and there are no imbalances or disparities which are created due to the use of technology. The second is the technical issues or the lack of reliability which we may face. We know that online mediation is really good, but what happens if the light goes off? We have no electricity. Or what happens if the internet is not there? Or what happens if the software has certain glitches? So we as mediators have to ensure the participants' engagement throughout. We have to ensure that the process is smooth. And we must always have a plan B. So we may feel that though this online mediation would be conducted in a very seamless and very comfortable manner, but all of these glitches can sabotage the mediation, and we need to have a plan B. We need to know that in case of such a error, how do we wrap up a session? How do we scan the progress, and how do we make sure that we build a foundation that the parties can build upon in the next session that we have. So again, it's our role to help us circumvent these technological barriers and the technical issues that we may face during mediation. Then some of you may think, what about the security and the confidentiality? You are talking about WhatsApp, you're talking about Zoom. So many of these tools can have data breaches. They can be vulnerable to hacking. They can be vulnerable to unauthorized access. Which can really go ahead and compromise sensitive information that many of our participants may share during the mediation process. So, as mediators, we need to properly vet what softwares we are using, whether those softwares the companies have proper data protection laws, whether those companies actually follow the end-to-end process, the encryption process to the T, and what are the reviews that those softwares have had. Have they had a history of hacking or a history of data breach? And all of this needs to be taken into account when we as mediators are choosing the online platform that we seek to use. And what else we have to do is we have to make sure that we are very open and transparent to the participants to explain to them what can be the pros and cons of using that particular software. So there is informed consent in the truest manner. What are the benefits of the tools that we are using? What are the potential risks that they would have? Reassure the participants that their information will be shared or stored in a confidential manner, all of these things. So that is something that we need to take care of while dealing with security and data breach issues, is to number one, vet the software that we are using, read the reviews, and number two, be completely transparent with our participants as to the pros, the merits and demerits of the software that we are going to use. Then another thing that many of us say, that what happens, communication is not just about talking. It's also about our body language. It's also about the non-verbal cues that we use, as many of us would have been taught in the previous sessions, that, paraphrasing or active listening or, really engaging, nodding, acknowledging, all of these become very important part of mediators' communication skills. But much of this non-verbal communication and body language aspect could get lost as part of the virtual mediation. And we as participants, we may not be able to understand the other person's emotions, the other person's intentions, and all of this can lead to a lot of misunderstanding. So yet again, it is our role as mediators that we have to be even more proactive. We have to make sure that we paraphrase more often, we acknowledge more often, we are more active in making sure that both parties are heard, and be very sensitive to the subtle non-verbal cues that people can engage in or deliver during an online mediation. So this is something that we need to really care about. Then the challenges don't stop over there. We know that somehow many a times virtual platforms can seem very impersonal in nature. There's a very different vibe which comes with real-time face-to-face interaction. So a lot of people feel that virtual platforms can reduce that kind of emotional connection or that relationship building that can happen during a physical session. So they may feel that the trust building opportunities might reduce during the mediation process. Then, of course, as mentioned before, over-reliance on technology can be, can be really a challenge for us, given the technological divide, the digital literacy divide, and, the technological glitches that we can have. So like I mentioned before, we must not be over-reliant on technology. It's a tool to support us, but of course, it has its own lapses. Then another part is the ethical considerations that we may have, due to people, like, well, I talked about confidentiality, I talked about informed consent, I talked about, being extremely transparent in the process, ensuring accessibility, ensuring effectiveness. And these could also pose a slight dilemma in an online mediation. So we as mediators have to make sure that we provide a very safe and respectful environment to our participants. We must ensure that there's a collaborative, atmosphere created where constructive dialogue is encouraged and active participation from our parties is enabled. And like I mentioned, we have to be even more proactive to ensure and be particularly very sensitive to non-verbal cues to ensure that this process is ethical, efficient, and effective and satisfactory for all the parties involved. and to ensure that it's a fair and balanced process. And last but not the least, as in physical mediation, unpreparedness or underpreparedness could be an issue, So we as mediators, we need to be well aware of the pros and cons of the tools we are using, the process, as well as, what lapses that there could be and how to deal with them. Another thing that we could do to improve this preparedness is, like I mentioned before, you may schedule a pre-mediation meeting. It's something like a test session where you make the participants aware of what technology is being used, how, whether the camera is working, whether the audio functioning is working, how they will be using that platform, run them through a demo, make sure they're, testing everything is working and testing in both the parties, all the parties are comfortable. Then we should also create a participant spreadsheet, which has the participants' affiliation, the name, the role that they play, their email addresses, telephone numbers, and we must also prepare what we call a process document, which gives a description of the process that will be undertaken during online mediation, what the technology will be used, and this document may be shared with the participants before the test session itself. And like I mentioned before, like I mentioned that these are some 7-8 challenges that we can face during online mediation, but that in no way means that the advantages can be overridden by this. We just have to be much more proactive. We need to give more feedback. We need to be more sensitive to non-verbal cues. We need to be well acquainted with technology. We need to be sensitive to parties' different levels of digital literacy. We need to take care of confidentiality and security issues. And we also need to stay updated with e-mediation rules of different countries, especially if we are engaging in international online mediation. What are the professional requirements of the country in which the mediation is happening? How do we enforce an online mediated agreement in times of, say, a non-compliance where parties are not meeting physically? What are the regulatory frameworks that can impede or help us reach our goals? Like I mentioned, the laws and regulations that would be applied to certain this kind of mediation. So all in all, I would like to say that while technology does enhance the mediation process, it is our role as mediators who, we play an extremely crucial role. And we need to understand, to make online mediation a success, we need to have careful planning, a robust technological infrastructure. We need to be well versed in effective communication strategies, especially for the online platforms. And here is when these trainings that is organized by BIMS, these recurrent trainings are very important, not only to make our participants aware of the new fields, but as well as the best strategies to equip us to leverage the opportunities that online mediation may present to us. Now, I've spoken about platforms. I've spoken about the integrated ODR, the different platforms I've used. I've shared the advantages as well as the challenges that you can face. But it doesn't end here. While many of us are used to using WebEx, Zoom, Google Drive, WhatsApp, the future of online, ODR, and the future of technology integration in the legal system does not end here. And there are numerous future trends and possibilities that we are seeing, some of which I mentioned earlier, and some of which I'm going to share with you in these 2 slides that I have prepared. The first thing is that increasing integration of artificial intelligence and machine learning techniques inside the ODR process. So what does this do? There are certain technologies or there are certain softwares and algorithms which can analyze a large amount of data in a very short time. And they can identify certain trends, they can identify certain patterns, and they can provide insights to the decision-making process. Like I mentioned before, these softwares can, through how the people are talking, what their behavior is, what their non-verbal cues are, or what are the kind of statements that they are making, they're able to predict what the outcome of a mediation would be, or what are the possible, potential options that can be generated, which could provide a win-win solution to both the parties. They can also somehow pinpoint on certain misconceptions, misunderstandings, or potential biases which parties may have. And all of this is through the use of artificial intelligence, machine learning, and similar techniques. So so when I mentioned the integrated ODR platforms, there is more and more integration of artificial intelligence and machine learning capabilities within these platforms that these platforms are using. However, we must realize that, like with technology, we cannot completely rely on artificial intelligence, and nothing will ever, at least as of now, circumvent or override the human element. And so we need to strike, we know that we have to strike a good balance between automation as well as the human involvement to ensure that the process is fair and effective. Then the second part is an integration of data analytics and predictive modeling, which is a subset of what I've already mentioned. So analyzing data from past similar mediation cases based on what the preferences that the parties are sharing or what their behavior is, they're able to kind of come to what the potential outcomes would be, what the potential bottlenecks would be, and what would be a good way for the mediation to go forward. And this could be basically provide a certain groundwork or certain nudge to the mediation in parties to go towards a more win-win solution, if that may be. Then the third part, blockchain technology. Many of you would be hearing about these buzzwords like blockchain technology, cryptocurrency, so on and so forth. In very simple terms, this technology, and one of the application of this technology, is that it can help you store data in a very secure and transparent manner. So, for example, it can, in mediation, these kinds of technologies can be used in ensuring that the document authenticity is retained. One such application is, say, smart contracts. So smart contracts are able to automatically perform certain data verification processes, and they can automatically perform certain processes based on retrieved data. For example, if there is a consumer dispute, and once the dispute has been resolved, the funds, if any, which have to be disbursed as a part of the agreement, will automatically be disbursed without any human involvement through the process of smart contracts. So, I just mentioned one such application. There are many, many more such applications. But however, we know that rigorous testing and auditing of these technologies is essential to enable that they're very secure. Then, right. Then I'll talk about the increasing integration of virtual and augmented reality. So what is this? Many of you would have heard about metaverse. So we talk about the feel of a physical space. We talk about face-to-face interaction. And you may say that, yes, okay, Zoom, WebEx, they allow us to engage in real time, face-to-face, but that still doesn't do away with the feeling of a physical person in front of you. We are, however, noticing that there is a more and more integration of virtual and augmented reality in these, in these softwares and platforms. What this does is it creates a 3D sort of environment in which once you, use this technology, you feel that you're actually present inside a room and you're actually talking to another person as if that person is sitting in front of you on a desk. So, it provides a much more immersive and interactive experience than what you may see the other video conference platforms doing. However, this is just the beginning. And though it is a trend, it will take some time for this to be scaled up and integrated in our normal mediation platforms that we have. However, this can really help us get that real world experience that we want, which we have in physical mediation. Then, like we mentioned that, with the growth of mobile and cloud-based technology, there are increasing tools, there are increasing platforms, there are increasing softwares which are being developed, which are basically these cloud-based mediation solutions. Because they're so convenient, we can just get online using our mobile phones. So many of these platforms are being designed especially for, small, using on a small desktops, mobile phones, tabs. Fine. It's fine now. Why is it like? What happened? Is it? You just need to start your video on top there. Okay. Left corner. Top left corner. This top left corner. Right. You start your video. Right. So earlier I mentioned that online mediation is perhaps a more impersonal process. You're not able to understand people's body language properly, the non-verbal cues. However, we see that there's a growing integration of emotional intelligence and empathy-related factors um, driven technology within these ODR platforms. So there is this emotional recognition technology or sentiment analysis which is being used, so integrated in these online platforms, which help understand participants' emotions and what their underlying concerns would be. And this is so difficult for many of us to understand, but this is actually the reality which we will be seeing going forward, is to be able to feel like a 3D real world while interacting remotely online, is to have very convenient access to online mediation through the comfort of our smartphones, is to integrate that human intelligence and that human element as part of ODR platforms as well. And this is something which was unheard of some years ago. Now, I'll just give you an example that, we may feel that these ODR platforms are just being used in, say, commercial mediation or amongst individual clients for their everyday cases. However, not. For example, in my field, I work in the Ministry of Commerce in the Government of India, and we deal with trade and commerce related issues. And as you may know that, where there is trade across the world, where there is globalization, where there is commerce and commercial contracts, there are bound to be disputes. So one of the leading UN bodies, which is the UNCTAD, which deals with trade-related issues, has actually funded a technical cooperation project, which is basically understanding what the current global setup of online dispute resolution tools are, and to what extent they can be used in resolving international trade disputes. So earlier, like today, to be honest, we mostly go to the World Trade Organization, or we engage in arbitration, or we take to mediation, but in a physical platform, because the nature of information is so classified that and confidential that it can get really risky. Many of us as governments feel that it can be risky if we take the process online. But when we see research like this being done, especially by international organizations who are driving trade and commerce, we understand where the winds are moving, and which is towards technologically driven online and virtual modes of dispute resolution, even at the level of international governments and multilateral organizations. So I'm almost going to come to the end of my lecture today. So we've spoken about the advantages, we've spoken about the needs, but in setups where even mediation is just coming about, in setups where we are just beginning to talk about a mediation law in our countries and a need for that, we're already leapfrogging to online mediation and the use of technology. So it's extremely important to have the correct regulations, or what I may say, the e-mediation rules, or certain rules governing online dispute resolution processes, to ensure that the mediation process remains fair, secure, and objective. And if any of us are here, which may tomorrow, become a part of this e-mediation rules-making process, there are some fundamental, principles that we can keep in mind to ensure this. Firstly, we have to make sure that in our jurisdiction, whatever tools or technologies or software that are being used for mediation prioritize confidentiality and data security, and that the platforms have robust security measures, because we are dealing with such personalized and sensitive information. This becomes extremely important. Then these e-mediation rules should also specify the technical requirements which may be there while participating in the process. What are the kinds of internet connectivity that we may have? What are the compatible devices? What are the softwares or platforms that are being used? And all this information should be shared in a transparent manner. Then, while talking about the process, What would be the process for the virtual communication which would happen? How would the documentation be? What are the security and data breach sort of parameters that we need to take into account? How would these documents be electronically handled? How would agreements be reached? How would they be executed? What kinds of proposals? So there are so many things which we have to take care of, and this is something that e-mediation rules, at least at a principal level, must ensure, so that we're able to maintain impartiality and neutrality and fairness in the mediation process. Another thing that is encouraged is that we provide a form to the parties so that the parties can initiate the procedure. So there are different ways for e-mediation to come into place. It can be put into motion by both the parties simultaneously. They can be put into motion by one of the parties by asking consent. So notions of informed consent. What are the languages that is to be used? How will the communication happen between them? Will it be in real time or will it be in writing in deferred time? How would the joint or caucus sessions take place? Who will be the participants? How would the drafting and signing of the agreement be? So all of these factors need to be taken into account while drafting the e-mediation rules to ensure that the process is carried forward in a very effective manner. And like earlier, I mentioned the countries which have taken to online mediation very, very effectively, like UK, the US, Canada, Europe, Singapore. All of these have already begun to incorporate provision, or they have developed specific laws and regulations to accommodate online mediation in their legal system. For example, in India, because we are acknowledging the growing relevance as well as advantages of online dispute resolution, online mediation has been proposed to be a factor and has been taken into account while drafting the mediation bill in 2021, which would become a law in India. In fact, the Planning Commission, or the head policy making body of India, which is called Niti Aayog, has also constituted a high level committee, which is set to develop an action plan to mainstream, say, e-mediation or online dispute resolution in India. So, all of these are legal developments as well as regulatory framework which countries across the world are building. So when we are talking about taking to online mediation, we as stakeholders should also play a part to ensure that the legal and regulatory framework around this ecosystem is, there properly there as well. So lastly, I'll just, share that we understand that today the use of technology across spheres is inevitable, as in, online dispute resolution. We know that it enhances accessibility, flexibility, efficiency, while maintaining, we have to make sure that all of this is ensured while maintaining the integrity and effectiveness of the mediation process. And it is essential for all of us to, proactively learn and proactively participate and adapt to the unique dynamics and challenges that online mediation can bring to us, and equip ourselves with the skills and the competencies to ensure successful outcomes in the online mediation process. So yes, with this, I come to the end of my talk today. I hope that through my short presentation today, I was able to add some value to your understanding of the growing role of technology and integration of technology in ODR processes, as well as, helped some of you become aware of the different platforms which would address. If any of you may have any further queries or details that you may want, you may reach out to me on this email ID. And if any of you have any questions with respect to the session today, I would be happy to take it. Thank you very much. And this option. Yes, so if any, the BIMS desk, it's muted right now. So if anybody has any questions, you may ask me.
Good morning.
Good morning.
Good morning, Tanushree. This is Matrika.
Yes, you're audible.
Matrika. Well, thank you so much for brilliant presentation as usual. But I have just one question to you. What about confidentiality of mediation during using online platform?
Yes, thank you for your question. Like I mentioned in my presentation itself, maintaining confidentiality and privacy, especially of the sensitive information and the documentation which is shared during the mediation process, could become a challenge. And like I mentioned, that is where our role as mediators comes to play. Firstly, to do proper vetting of what are the technologies and softwares that we are using for the online mediation process, whether those softwares have proper data protection measures, whether they have proper data protection policies governing their operations, and whether they have any, and to go to and see their reviews that they have with different other people would have had while using those platforms. So doing our own background check and vetting becomes very important. Secondly, secondly is the need for having e-mediation rules in the jurisdiction in which we would be undertaking mediation, to ensure that there's a regulatory and legal framework which can help maintain confidentiality of this information. Thirdly, I mentioned that there's a growing integration of technologies like blockchain technology, and which is even better than platforms like Google Drive or the other Dropbox, etc., that I mentioned, which can provide an extremely safe and confidential and secure manner to deal with this. But for this, the different ODR platforms need to really evolve in order to integrate these kind of technologies within their ecosystem. And another thing that we need to do is that, knowing the sort of problems that we may face, we need to be transparent with our participants, and tell them what are the merits and demerits of this. And after doing a background check and vetting, we need to ensure that their documentation and their everything would be confidential, and everything would be secure. So it's like a four-step thing. Firstly, doing our own background check and vetting and looking at the reviews, making sure that we deal with very safe platforms which have data protection law. Secondly, working in a space where we have some kind of legal and regulatory it's fine, it's okay. Working in a place in which we have certain regulatory frameworks to help us. And thirdly, being very transparent with our parties while explaining the process.
Tanushree, this is Geeta here. Just one request. Please show Mr. Goswami the trophy which BIMS gave me, how it occupies a place of pride in India. It's right behind you. Just bring it in the front. And Chandrika, would you move the camera down? The upar ka zyada dikh raha hai. Yes, please show Mr. Goswami.
So it's the trophy that was given to Justice Mittal, which sits very proudly in our office, and which is seen by everybody all over the world whenever we have international dispute resolution processes over here.
Thank you, beta.
Thanks.
Is there any question? If there is
Right. So if there are any more questions, please let me know. I think there are probably no more questions.
one for the next session?
Yeah, sorry.
You have Booklet with you now?
Yes.
Can you open the page 10?
Sir, maybe Tulsi ma'am didn't hear you. Maybe Tulsi ma'am didn't hear you.
Sorry, your voice is breaking.
So, so between 2:30 and 4, we have MCQs, that's multiple questions. Question book will be circulated at 2 o'clock. Instead of 2:30, we circulate at 2 o'clock. Our lunch break is curtailed by half an hour. So you will have only half an hour lunch break, 1:30 to 2. And 2 to 3 will be our MCQ. And 3 to 4, we will have Honorable Justice Korean Joseph speak on why mediation is the best method for dispute resolution. So are you happy to appear for MCQ examination? Yes, no? Yes. So let's revise or recap what we have learned in the last 3 days, so that I'm trying to brush up your memory, so you are very good to answer the questions. So what is ADR? Is that internationally accepted abbreviation? It's alternate dispute resolution, and additionally there is a debate which is going on, which is not officially announced, right? So maybe if there's a question, what is ADR, you should not write additional. And I will not be responsible for it. That's a disclaimer. I will not. I will not. If I'm going to evaluate, I will not. Then again, what are the components of ADR? What are the components of ADR? Is negotiation a part of media in the ADR spectrum? Yes. And unfortunately, you have that slide with you? The first day slide. If you can share it from there. And negotiation, the structured negotiation assisted by a third party, a neutral third party is mediation. So is negotiation a part of ADR?
Equal process problem.
Somebody?
Equal process problem.
So that's a triangle. What you're talking about.
This one, sir?
So just go on. You have a spectrum. Just go on. Just go on. No, go up 3 pillars of mediation. No, 3 pillars of that's negotiation, mediation, adjudication, 3 pillars, and negotiation. Yeah, you can go down again. Now you can go down. Still. You can go down. Yeah. So what is ADR here? It's mediation, conciliation, adjudication, and arbitration. Right? Negotiation does not fall under the definition of ADR, and litigation does not fall under the definition. So if there's a question, what is alternative dispute resolution? It's only mediation, conciliation, adjudication, and arbitration. Right? And then what are different types of ADR? Spectrums of ADR. 6 spectrums of ADR. What are they?
Difference, conflict, sorry. Difference, conflict, where
6 types of ADR spectrum. So facilitative, negotiative. Yes. Preventive. Fact finding. Advisory. And enforce. Right? So those are the spectrum of area. And then what questions can you probably expect? And who controls the outcome of AD? Parties. Parties control the outcome. And who controls the outcome of arbitration? Arbitration. So it's also there. So parties are the court controlled in arbitration, whereas parties have the absolute control of the outcome and mediation. And what is the role of a mediator? Facilitator. Is that only one? Thank you, sir. Thank you, sir. Yesterday we saw five types of roles for mediator. Is a convener. Is a interpreter. Is a translator. Is a facilitator. Anything else? And then what is the difference between mediation and arbitration? Arbitrator is a third party. Mediator is also appointed. Mediator is not mandatory, it becomes negotiation. You will not be mediation. In arbitration, the arbitrator can make a decision based on evidences and other things, but in the mediation, the mediator cannot give a decision. The arbitration is more dependent on the court, and in mediation is more dependent on the conclusion of the parties. Right? And what is the difference between litigation and ADR? Court procedure. Yes. And this is out of. Yeah. Formal and informal. Right? Formal and informal. Is the agreement binding in ADR agreement binding on the parties?
Yes.
How?
Voluntarily
Voluntarily agree, but still voluntarily I can walk out. After his side, then how is it binding? Enforced by law. Enforced by law, then it becomes binding. Until it is enforced, not enforced by law, it doesn't become binding. Okay. And what is early neutral evaluator? What does it do? Early neutral evaluator or fact finding expert. Is he a mediator first? He's not a mediator. He's an expert. So, what is his role?
Access party, leader or his advisor or expert assist the party to explore the options.
He is a mediator.
No, he is not mediator.
No, the one who assists the parties to evaluate and arrive at a conclusion is a mediator. We are talking about who's an early neutral expert or who's a fact-finding expert. Parties are not fact-finding. He can be a subject expert or he can be a legal expert to whom you give all the evidences, documents, and he does the fact-finding analysis, and then he is going to give a report. And the report is given to the parties, not to the media. Right? And what are the disadvantages of mediation? It's voluntary process, so anytime anyone can opt out. Is there any other disadvantages? All cases cannot be handled through mediation. There are only cases that can handle. Is there anything else? The enforcement of order. Can I say that biggest disadvantage here is, as a party, I voluntarily come for mediation and then try to gauge or understand what the opposite party's mind is. And then I walk out. Knowing what is as advantages, disadvantages, I walk out to see, to try out that in litigations. That's one of the biggest disadvantages. And I said 3 articles from Singapore Convention is very important. What are they? 3 for me. What does that say? We talk about
Three process for example and five paying.
why mediation. What are the different areas where mediation? So what are the different options the mediation can take, or different ways the mediation can take?
There is no confidence.
There is no confidence. Impartiality is not maintained. Then trust is not built up. Then why it should not be? No, why? We are only talking about why the mediation is paid. When there is a conflict of interest, the mediator with other party. Mediator. Sympathy instead of empathy. Conflict of interest. Biasness. Being biased. Unethical attitude. Then anything else? What you can think of? Why pay? So no one read out of it. I'm not expecting. If the mediator imposes the decision, but whereas in the spectrum we saw there is one imposed. Area spectrum also calls one imposed. So can anyone say? She said, if the mediator imposes the decision, then the mediation fails. But in the area spectrum, the last aspect we saw is imposed mediation. So why is that? There is a contradiction. Or why is it contrary? Can anyone say?
Party will control the
Yes.
what are what will
Yes.
that's why it's not.
No. The area spectrum talks about imposed. There is an element of an imposed area. And Article 5 says a mediator cannot impose his resolution or he cannot impose his ideas on the parties. Is it not contradictory? No, we saw only 8 spectrum. If you go back and brush up your memory, can you go back to the imposed? And imposed is as per the statutes, as per the code. If the law says this, you cannot go against, but it is imposed by the statute of the rule book of the parties. So that can be imposed. Whereas the decision, the outcome cannot be imposed by the mediator on the party.
Process and the ground rules.
Okay. then it fits. Then it fits.
You must focus on ground.
No, that is mutually agreed at the beginning. Yeah, so the area spectrum imposition is something different, which is based on statutes, which is based on code, which is based on rules. Whereas a mediator, as per Article 5, the mediator cannot impose because mediation is voluntary, it's people-centric. The parties are responsible for arriving at a solution, right? Why some mediations succeed and why some mediations fail? Like it, apart from that, let's talk as mediators, not as partners. Now we are going to become mediators in few hours from now. I can hear only 2-3 of them responding. What about the others? Let's make it more interactive. There's nothing called right or wrong in mediation. You can end up with a settlement. You don't end up with a settlement. So there's nothing right or wrong. So let's have it more interactive. So that's where mediation succeeds and mediation fails. And what do you think is the heart of mediation? Is it the process? Is it the stages? Is it communication? Is it identification of spectrum? Is it identification of disputes? What do you think is the heart of communication? I mean, heart of mediation.
Communication.
Conflict. Conflict. Any answer? Communication. Win-win situation. Anything else? What are the 5 stages of mediation? What is the 3rd stage of mediation? Exploration and negotiation. And what is required for exploration and negotiation? So communication is the heart of mediation. You can set up ground rules, you can set up stages, you can set up processes, but if the parties are not going to open their mouths, they're not going to be interactive, like some of you are not interactive. Then it means, yeah. So that's the heart, or that's the most important aspect of mediation. So the interaction is the most important part. Otherwise, nothing. And what are the different types of referral? Referral. So that's decision making. We are talking about referral. Voluntary referral, mandatory referral, right? And what is voluntary referral? Can the court intervene in voluntary referral? Right? The court can also ask you to go for mediation, which if the parties are voluntarily accepting, right? So court has got a bigger role to play. And the mandatory referral, it's mandated by the court. And what is the essence of mediation? Voluntariness. And mandatory referral, is it voluntariness for parties? It is mandated. It's mandated as per the civil procedure.
But they can post
Yeah, that's up to the parties. They can agree or disagree. That's something. And what are different types of decision making? The interest based and right. Interest based and right. Right. Okay. What is right based and what is interest? Right based is position. Right based is position. law, sticking out to the law, sticking out to the statute, sticking out to the law, and interest based is my personal and my goal to achieve. Interest is goal to achieve, and rights is statutes, law, and positions, right? And what is negotiation? What is negotiation? Communication process to arrive at a possible solution, not agreement. Negotiation does not result in agreement, it's only arriving at a solution. Mediation results in an agreement. Correct. So you should always have the difference. The structured negotiation assisted by the third party or neutral third party is a mediation which results in agreement. Can mediation result without an agreement? Possibly yes, at some time. It is not a thumb rule that all the mediation should end up with an agreement. And negotiation is between how many parties? Okay, only two parties.
More than parties.
More than two parties. Who's the third party? No, he said for the two parties. I'm asking who's third party.
There are more other parties. 3 or 2 more.
Okay. There could be a possibility where we have many parties. If you have a land, and the land has 4 boundaries, and all the 4 parties can also dispute. So you'll have 5 disputing parties, right? And what are different types of negotiation? Think about it. Have a tea break for 15 minutes, and during that 15 minutes, quickly go through all your notes. We will recap whatever we learned in the last video. So we will assemble at 11:15.
Recording stopped.
Suddenly you say I
No. Excuse me, भैया मैम
If you take past months, you'll be entitled to KSF.
used to put
Yeah, I know.
them out and
Yes. Everything.
Yeah.
Marking.
I'm serious now. Is it a one choice answer?
ABC multiple.
So you can mark more than one.
No,
Only one.
Yeah.
One so you can mark more than one.
So some cases are there. All the above, both A and B star, both B and C star.
One.
Yeah, yeah. Out of 4, only 1 is a right.
Confusing answer. I think confusing answer. Tasty.
No,
You can try.
we get lot and we get.
Yeah.
Every time you get lot.
Tasty. Tasty food. I love this. Mango.
For Nepal also.
Yes. Yeah. Student. Summer school. Summer school. You like this? Yes. Please come. Okay, please. Third one. This third. Then I come. Then
Let others join. Can mediator be a counselor?
No, no,
No. Can mediator be an advisor?
no.
What are the different types of negotiation? Distributor and integrator. And two types of and what is distributor negotiation and what is integrated? Distributor negotiation is a fixed file where both the parties know that
Recording in progress.
what we are going to get. Distributor between both and integrator was you are trying to achieve more than what you want. And who can be a negotiator? Can a lawyer be a negotiator?
Yes.
Yes, no. And parties can be, only parties can be negotiators. Yes. So always remember, negotiation happens between two parties, mediation happens between right? 2 and 3 years. And what are the stages of mediation? Pre-mediation stage, introduction stage, opening. Okay, that's okay. That all is the process, right? Stages. Five stages of mediation. You have pre-mediation stage as introduction and opening statement. Then joint session if required and private session. Then closing and agreement. And what are the process? Preparation, introduction, storytelling, exploration and negotiation, problem solving, conclusion, and agreement. And agreements, right? And in exploration and negotiation, what is the important aspect you can think of? Generating options and allowing both the parties to discuss on issues. And can there be multiple solution to a dispute? Maybe. Yes. Still be. And when you arrive at a solution for the dispute, you have partner, and Zopa. What is partner? There is alternative available here. What is partner? Worst alternative available and Zopa. Interest, common interest. Right? And when do you do this analysis? Partner, Zopa, and who does the analysis? So when you do the analysis, whether you want to go without partner, whether you want to adopt partner, or whether you want to. At which stage do you do the analysis? Pre-mediation stage, right? And will the mediator also do the analysis? Or it's only the parties who does the analysis? Parties does the analysis. Will the mediator also do the analysis? Yes. Yes. He will do the analysis because he has to understand what the problem is. Right? So when the mediator does the analysis, can he impose his analysis on the parties? He cannot impose the analysis on the parties. And partner, let's talk about partner. Is partner fixed? Let's say at the beginning, you do your analysis and you fix a partner. Is partner fixed? So it can change. As and when the exploration and negotiation goes, it can change. And partner is fixed, or can it also change? It can also change depending on your exploration and negotiation. Can ZOPA be fixed, or can it be also a variable? What are the two types of decision making? So when you decide on the interest, so that means you're not going up to give up your interest until and unless there is a transition, right, from interest phase to right phase. So therefore, ZOPA may not change. It will be always fixed. It may not change. It's only in rare cases it changes, unless you shift from interest to right or right to interest. ZOPA is interest based of both the parties, right? All right. Then what do you do in joint session? As a mediator, what did you do in joint session? Come again.
Exploration and negotiation.
Exploration and negotiation. Okay. Apart from that, you will allow the parties to discuss. You will prompt the parties to discuss, and that's how you do the exploration of disputes. And when will the dispute be fixed? As a mediator, when you fix a dispute? In the opening session. The opening session, party A makes a statement, summarize, party B makes a statement, mediator summarizes, then you do the dispute fixing or dispute finalization. And based on the dispute only, you do the exploration and negotiation and the exploration. Right? If there is no settlement arrived, let's say after 3 days of mediation, no settlement arrived. Then as a mediator, what will you do? Not settle. Okay. And out of 4 disputes, 2 settle, 2 not settle. 1, 2 settle, you will define what is settled and you will define what is not settled. And can a mediator elaborate why 2 settled and 2 not settled? No. You cannot elaborate. Can a mediator in his report write anything other than settled or not settled? He cannot. And when the mediator makes a report, is it mandatory for him to take the signature from both the parties? Yes.
Yes.
Right, my question is, a mediator makes his report, is it mandatory to take the signature from both the parties?
On the
Report.
no,
Report is the report of the arbitrator. That's only for the record. That's not going out, it's only for the record. So it only says it's settled or not settled. And when you write, yeah.
No, I mean that not mandatory, not compulsory.
And when you write an agreement, who writes an agreement or who drafts an agreement? Parties write and they draft their own. Can mediator draft an agreement on behalf of the parties?
No.
Yes. A mediator can also draft the agreement if the parties agree to do so. And he will record it very clearly. He has drafted the agreement on behalf of the parties upon their concurrence and their interest. And who will sign the agreement? Parties. Can mediator sign the agreement? Yes. And Singapore Convention, does it mandate the mediator to sign the agreement? And what are the steps to be followed in the agreement? How do you draft an agreement? First framework, preface, then exploration. No, you have to talk like a mediator. Preface, exploration, and what do you explore? Explore the disputes. The preface, you are defining the problem, you are defining the dispute. And exploration, you are exploring those disputes. And then negotiation, generating options, then it is timeline. Operative part. Operative part, you will say, out of the multiple options generated, this is the partner which has been agreed. And then the execution of the operative part, the timelines. And then, yeah, correct. And then certification, correct? Certify that it is drafted by whom, without external pressure, who, this, that, and everything. And finally, execution. This is executed between so and so and so date. And if you want mediator to be an witness, you add his name as a witness. But as a mediator, it is always advisable. You also sign as a witness. So it is there on the record who the mediator is. And this is not only between the parties, it is the concurrence of the mediator. I mean, it is in the witness of the mediator that they have discussed, negotiated, and arrived to a conclusion.
In case of agreement, is this case of requirement for mediator? One or more participants? Can one or more participants?
Ideally, it would be better to have one, because the more person you appoint, there will be more conflict and there will be more difference. Yes, even if necessary, yeah, it's a mutual consent. If you have money to have 2-3 people, tribunal also. And when the agreement is made, is it binding or non-binding? So not binding. Not binding. That's it. Enforced right? And in the stages of mediation, how will you set the ground rules? As a mediator, during the stages of mediation, such ground rules have to be set. What are the important ground rules you will say?
Confidential and not blame to talk out.
So that's in the pre-mediation stage of opening.
Venue, it's the venue.
In the stages of mediation, the most important thing is set as the process. What is the process and how you are going to follow the process and what's the process? That is what you are going to say. And the court, in the mandatory referral, let's say the court has referred, is the court entitled to summon the mediator? No, yes.
Yes.
Can the court summon the mediator?
Court can send a notice. Not exactly something. Notice.
Or can the court call the mediator to testify?
Yeah.
Huh? Now you go back to the court and say that we are solved.
Yeah.
And during that time, can the court call the mediator to testify?
No,
No, the court cannot call mediator to testify. Why? Confidential. The process is confidential. So you cannot summon the mediator. And can the mediator publish some of his? No, he cannot submit. Can the mediator be partial? No. And what are the elements of effective communication? Listening, understanding, analyzing, learning.
Yes, sorry.
Come.
Yes, sorry.
And
Yes, sorry. Yes, sir.
Yes, sir.
seven C. No, that's seven. C's, that is communication, types of communication. That is types of communication. And in communication, what is the most important formula? Or how do you define communication?
Clear.
Yes?
Clear message, clear message.
Clear message. Will only clear message be a communication? Exchange. Sender, receiver, a medium, and a topic. Right? There are four important aspects. You need to have a sender, should be received by someone. There should be a medium. And what is the medium here? Topic. Verbal, non-verbal, return, audio visual, return. And then you should have a topic or a message. And how do you know that the communication is effective? Response. You should always have a feedback, which is known as a response. Once you get back the response, then you know that the communication circle is complete. So what you wanted to convey has been understood by other party, and he has responded back to you, right? And then communication, which is most important? Is listening most important, or understanding is most important, or conveying is most important? Everything is most. You cannot differentiate one from that. And which is widely used, verbal or non-verbal communication? Non-verbal communication. And which is easily understood, verbal or non-verbal communication? Verbal or non-verbal? Right? Non-verbal communication. And yesterday we saw some pie chart of some percentages, right? 16, 36, 40, 50%. So that's how the communication effectively works. And effective listening, what are the main characteristics for an effective listener? Eye contact. You have to be very careful when having an eye contact with opposite. By attentive, being attentive, being a good listener. You don't interrupt. 48%, throwing open question, feedbacking, prompting them. Anything else? Huh? Body language. Body language. Always summarizing. Summarizing. Yeah, summarizing. Yeah. So those are some of the important aspects of active listening skills. And why is why are those communication skills important for mediation?
Art of mediation.
Communication, art of mediation, that's the reason you have to have those skills. Right? And can party A or party B, after coming to mediation, can they separately have an agreement without a mediator?
Yes.
So exploration negotiation is with a mediator. That question is, party has come for mediation, and then the party thinks we will have a separate discussion to come to a conclusion without the mediator. Probably they thought the mediator fees is high.
So, in case of negotiation, they can, but in the mediation.
As the property said, mandatory to have sign of mediator, as a single condition, agreement should be in front of mediator.
So the answer is yes. Because area gives you the flexibility. You can step in, step out. You can agree, you don't need to agree, you can settle, you don't want to settle. That's what is the parties. And if the parties attend the mediation session and later on they think this is going to be a time consuming, and because the stages he has set, the process he has set is going to be time consuming, so let's have a informal chat and close it, which is also allowed. But will the mediator agree to it for an agreement? Mediator will not be a party because it's not a mediation, but it's a negotiation. So it is not part of mediation, so mediator will not be a party. So you will have some circumstances where the parties will come for mediation and subsequently during the tea break or during the lunch break, they might have a discussion among themselves and say, let's close it among ourselves. And it had also happened few times when I sat as a mediator. So therefore, in that scenario, you cannot submit a report because it is negotiation. It is not mediation. You don't need to have to submit any report. Because you are not a party to it, so you do not know whether they have arrived at a conclusion or they have not arrived at a settlement. Maybe both the parties will come and tell you that we had a separate talk and we have agreed, we have settled. But in reality, you do not know because you are not a party. So that means you can only say that parties have shown their unwillingness to continue. That's your report. Yes, sir.
And parties, they at some point, they say, okay, we are not moving towards various just sit together and negotiate each other and resolve the negotiation. At that time, the mediator should have to submit before the court or not.
He will submit the report that they are unwilling to continue.
That's
Because you are not a party or you are not a witness to whether the settlement took place or whether the settlement did not take place. Maybe the parties will come and say, yes, the settlement has taken place. When they go to the court, they will say, no, we did not agree to it. Because they are not signing negotiation, you don't sign an agreement. So for that reason, you will only say, and you do not know whether it's negotiation or not. So you only say they are unwilling to continue. You will send it back to the court. Right? So as a mediator, these are all very small things which you should always keep in your mind. And what is the role of a mediator? Yeah. What are the roles? Huh? Basically, he is a convener, so he convenes the meeting. Translator. And what is translator? Translation.
summarize and paraphrase.
What is translation? You're transiting from one mode to the other mode. What is the mode? Or dispute mode to it?
Parties are from different languages.
No. Transiting is from your problem solving more to problem solving. And when there is a cross culture, two different parties or two different languages are there, when the other party is not able to understand, you can always have a translator on a mutual consent. And the decision will be taken by the parties, not the mediator. And what are the ethics of the mediator?
Impartial.
Impartial. Confident. Yeah. In? declare it not of. Not judgmental. You cannot judge. Then trustworthy. Yeah. Impartial. Hmm? Anything else? Hmm? Yes. Honesty. Honesty is very important. And why honesty is important? You are honest about who you are, what you are. Yes. And then what is the ethics of a mediator?
All good qualities. Good.
All good qualities. As a mediator, you have your checklist. And how you divide your checklist? You have beginning or the pre, then during, conclusion, and post. You have 4 different divisions. And at the beginning, what will you do as a mediator? Ground rules.
Like the party, we can also be the experts, other laws.
Procedure to the parties. Analyze the facts. Yeah. Is it the ethics of the media? The checklist. What else? You will declare impartial. No politics. That's why. Correct. And then confidence. And during the ongoing process, what is the checklist? As a mediator, you will do that. Am I in control? Yeah. You can't have the same thing. Opening it also. Yes, yeah. Yeah.
The training phase, like one, if the prosecutor for the authorities are specifically, like, you can. And not forcing
Can
party.
you put that role of mediator?
Facilitating to discuss the council.
And conclusion? And after closing, last Tuesday. After closing, you will declare that everything has been discarded.
Yeah, this was the name of the
The last 3 steps. Yeah, you can go. In the beginning, yeah. No, you can go. Yeah. Before starting, no conflict. And no one said whether you will check whether it is suitable to mediate. And no mediator said the cost. So I believe you are not going to the solutions. If you are not going to declare what is the cost that you require. And during the beginning, it's not the same. You explain the process You explain the role, you explain the parties and consult the experts, lawyers to obtain their legal experts. And also neutrality, supporting both the parties to voluntarily make up their minds. Not going to impose. When you propose solution, I am clearly telling that they are free to do so. You don't force and you don't give legal advice, you don't give any counseling, and you have to also disclose that you're not going to disclose any secrets. And you will also say that they are at their will to quit the process whenever they want. And at the closing, the agreement is fair and legitimate. You will check the agreement is fair and legitimate. No party is forced to agree on that. If it is made partial, you will say partially settled and partially not settled. When agreement is not made, you will say no agreement, no settlement achieved. And after finishing, you will discard all the information and notes, memo, whatever you have seen, and without any concern of parties, you will not disclose it. And finally, you will show that the correct information of the case and certification, and I'm trying to improve my skill as and ability as a mediator through the process of continuous learning. Right? What is the similarity between a mediation and conciliation? Both involve third party, right? That's the similarity. And what is the, if you have to say what is the advantages of mediation, what will be the three advantages, top three advantages you would say? Low cost,
Voluntary.
time save, and
Voluntary.
voluntary.
So if you
I
are,
think for the-
Time saving.
it is not the relationship.
Why do you go to mediation? No one said agreement, mutual agreement. So, three important things: one is time saving, low cost, effective, and mutual agreement via negotiation, right? And who appoints a mediator normally? Parties. The court can also appoint me, right? It's not only the parties. The court can also appoint mediator. And can a judge be a mediator?
No.
No. Why?
Yeah, in Japan, yes, the judge are.
In Bangladesh, retired judge can be.
Can a judge be a mediator?
Yeah, that's clear.
Until he does not have the conflict, right? And is a mediator a judge, or a mediator is a counselor, or a mediator is an advisor, or is a mediator an expert or a facilitator? Facilitator. He is going to be a facilitator.
So one thing
Yes.
can be mediator, 2 or 3 person can do one case.
Unless and until you live together. Because it's cost. You are going to appoint three mediators, cost number one. And again, you will have three different perspectives. Because it's not necessary that all the mediators should agree. Yeah. And the Singapore Convention, when it is put into your respective country's mediation law, and which law governs mediation, or which court governs mediation? Your mediation act. Okay. Yeah. So your mediation act, if it dependent on some code or some statute. Singapore Convention, yeah, Singapore Convention is an umbrella. Then you adopt Singapore Convention, practice it, and make your own law. So that law should be compatible to your code and to your statute. And what code is that? Bangladesh. In Bangladesh.
Civil code.
Civil code.
It's
Section
for
89. 89 of the right?
family code ordinance also.
Normally it is dependent on your code, right?
In Nepal, provision of mediation has been provided in the constitution. So that before I figure out that.
All three codes are
Realistic, realistic, realistic act also have.
Is mediation an hybrid process? When does mediation become a hybrid process?
During the arbitration.
When mediation, arbitration, and then conduct mediation, or arbitration, mediation, and arbitration. You have got different permutation combination. So when it is linked to the other one, then you call it hybrid. So mediation as such is not a hybrid process. Can mediation be a private mediation, or it should be only court annex mediation? Huh?
Yes.
Or can be either court annex or it can be a private mediation. So the court annex mediation, who appoints the mediator, and where do you get the mediator? From the panel of mediators maintained by the court. And in private,
They also the institution which working.
it can be institution or it can be again private. So institution, the database is maintained. And in private, if I want to have a, I don't want to go to institution because the cost is very high. I want to appoint a private mediator.
Party can.
They are getting any mediator of this choice.
In Bangladesh, mediation is different from court. The party can choose their own.
One mediator, that is from the panel.
If the party is failed, then the
Court will
select.
yeah. And in the entire area spectrum, what is common? The entire area spectrum, what is common? What phenomena is common?
Party autonomy. Assisted.
Party autonomy. But in litigation, there is no party autonomy. Communication is common. Whether it's negotiation or litigation, communication is common. And what else?
But one thing is not clear.
Yeah.
What is it like constitutional? And constitutional code appoint can appoint a mediator.
So that's what we discussed. There are two types of referral. One is voluntary, the other one is mandatory. So voluntary referral is, I have the right, you have the right to refer to a mediator. Correct. But in certain cases, the law mandates before it's tried, it has to be referred to mediation. Yes. So that's mandatory referral.
Sorry, if in Bangladesh, if the parties are paying to choose a mediator within 10 days,
Okay.
the time has limited 10 days. Then the court will appoint the mediator. 10 days, after 10 days.
Okay. Mediate also a court appointed.
Every district has a panel of mediator.
One thing is not clear to me that what is the difference between mediator, mediation, and mediation and actually,
Can anyone ask this question? What is the difference between mediator, mediation, and conciliation? Come on.
Mediator is third party who has over the disputed matter.
Okay.
Mediation is the entire process. And reconciliation is
Conciliation.
like to communicate good purpose. Maybe I might be wrong, but you can.
Any other clarification, any other answer to this question?
Conciliation have the decision making power. Which mediator
Anything else? The basic definition of mediation: a structured negotiation assisted by a neutral third party. This mediation.
almost like
So it's a structured negotiation assisted by a third neutral party. This mediation. And the third neutral party is a mediator. So we got the difference between mediator and
Conciliation.
conciliation is almost like mediation, which is interchangeable. And mediation, the mediator will not advise on a solution, on a resolution. Whereas the conciliation, the conciliator will also advise on the solution. That's only difference. Is a mediator bound by code of civil code and evidence act?
No.
No. Are you sure? Huh? Mediator, is he bound by the civil code and evidence act? He is bound by the civil code. How is he bound by the civil code?
Some parties agree on certain points that he or she should know they need to be included on that. Mediator, because the sign.
Okay.
So we also verify that example.
maybe binding legal context.
He does not need to prove anything. So he does not need evidence.
So he is not governed by either the civil code or evidence, right? Why do you say so?
Because he has no power to prove anything or disprove anything.
He is
just mediate.
the mediator has no power to go through the evidence or to do any fact finding. The fact finding and evidence are done by parties, so evidence act is not bound. Is he bound by the civil code? He is not bound by the civil code because he sets the stages, he sets the process, which is given as a mediation act.
Maybe legal process, that is why main reason behind it. It's not mandatory or binding.
It's not mandatory or binding.
The mediator is not accountable to the court.
Mediator is not accountable. Why? Why is he not accountable?
He's not complying with the order.
He is complying to the order of the court. If it's mandatory referral, he is complying to the order of the court. Yeah, if the court says you have 30 days, you have to complete your mediation. So that means he is under the, he is obeying the order of the court. Then you said it's not
In connection with the order.
accountable. Is he really accountable to the court?
No.
Other than timelines? No. He is not accountable to the court. This is a confidential process, he is not accountable to.
But in case of failure of the mediation, is the mediator entitled to get the peace?
Yeah. Okay.
Get the peace.
Can you say this way that the mediator don't know any content of the case, any content of the dispute, but he knows the procedure. It does not know the content of the dispute.
That's the reason we have a pre-mediation stage where the parties submit a statement. So then you cannot say that he is not aware of the dispute or he is not aware of the case.
Court is supposed.
Then court will submit all its documents to the mediator and see. The mediator, it is his bounden duty to go through the document and then ask for the statement, summarize it, set the process, set the stages. So he cannot show his ignorance that he's not aware of the case or he's aware of.
So the leader or
Yeah.
leader of a party, we could advise him.
Yeah.
He also cannot be mediator because he can be partial.
He cannot be a mediator. But the judge who has who has heard the parties in the court cannot be a mediator. The counsel who has represented the parties in the court or who have represented the parties or who have advised the parties one way or the other on a dispute, they cannot be a party. They cannot be a mediator. Court of parties.
Who has repressed the dispute the country mediator?
Cannot be.
Mediator must be free from any
Exactly.
encumbrances.
Exactly. And what are the functional stages of mediation? He said 4 functional stages of mediation. What are the 4 functional stages of mediation? Four functional stages of mediation. Huh? It's again introduction, opening statement, joint session, and coming to a conclusion.
Summarizing.
Summarizing. That's it. All
Private.
Yeah, introduction. What are the functions of the mediator?
Mediation.
He facilitates, he assists the parties, then what is he is facilitating, he is assisting the party to generate outcomes, then he is assisting the parties to come to a conclusion, right? Arrive at a conclusion. Is there any probable questions what you can think of? What you might get? Because I do not know where. And who is the reference judge? The same matter. Who is the reference judge? Huh? Reference judge. The judges who hear the matter, not all the judges. The judge who hears the matter and refers to the mediation is called a reference judge. And what are the attributes to the reference judge? Will he decide the case or will he not decide the case before it's the mediation? Will he hear the arguments or will he hear or not hear the arguments?
But you are coming to commission of written.
Returns. So, reference judge, it need not be like only after the plaintiff submits his application. Under the first hearing, he refers to mediation. It's not so. He can refer to mediation at any given point of time. On sole basis or on the request of the parties. Before even the order is paid, if the parties request so, he can always refer them to mediation and give them an ask for natural justice. What happens when there is a deadlock or an impasse? What happens when there is a deadlock or an impasse? Private session. Yeah? Okay. And in communication, Is emotion important?
Emotional.
Yes.
Emotion is important. And how was emotion conveyed in communication?
I didn't think.
The emotion carried by
Words, gestures. The emotion can be translated to words, gestures, and your facial expression. And can a subject expert be a mediator? Can a subject expert be a mediator?
Yes, yes.
Yes. The subject expert can be a mediator. And bankruptcy or insolvency, can it be referred for mediation? Bankruptcy or insolvency. Yes. When will you refer it to mediation? The issue of liquidation notice or after before it? No? Yeah. I didn't. No? Bankruptcy or insolvency, can it be referred to a mediation? If it can be referred to mediation, at what stage you refer to a mediation? Insolvency. You all have insolvency. Insolvency rules. Bankruptcy and insolvency can't be referred to mediation. Once it's invoked, it cannot be referred to mediation. Only before invocation. Yeah. Yeah. Correct. So it cannot be referred to insolvency. Can the mediator breach the confidentiality clause? If it's a mandatory referral and the judge summons a judge requests the mediator to come and explain what exactly happened in the mediation. Can he breach the confidentiality clause and explain what exactly happened? No. Even in the chamber? Assume in the chamber.
Like providing information. Otherwise, if party this would not disclose.
That's only an exemption. Only if there is an exemption, then they can always see whether it can be disclosed, or otherwise he cannot disclose. By law, he is not entitled to disclose anything to the referral judge. And can the referral judge change the agreement, mediation agreement?
Yes,
Yes, no?
yes.
Why yes?
Because he referred.
No. He referred to mediation. In the mediation, they came to an agreement. The agreement is signed between both the parties. Now they go back to the referral judge. Is the referral judge entitled to change a part?
No,
Or
no.
why?
He is bound to accept.
Both parties should be.
But if
If it is against public policy,
yeah, if it is against public, then.
if it is against the rules, so there is an option that if it is mandatory referral, once it goes to the court for enforcement, if it is against the public policy, the judge will have his own power to, yeah, to change or to separate, severe those paragraph
Modify.
modify the whole thing. And what is the difference between court annex mediation and a private mediation? Court annex mediation is normally the mediator is normally a retired judge or somebody from the bar. Right?
Associate.
Others as well, because the court,
When you are talking about a court annex, I don't know your country.
Yes.
In my country, it's always the retired judges or the senior advocates or some advocates from the bar.
but in you have, what we have problem is that each year, the mediation center of court announcing the policies, notice to this mediator.
That every country does.
Yeah.
And even the non-lawyers are advanced.
Yeah.
But
even
they will
the-
not get an but they will not get an opportunity.
Yeah, it's because of the mediation center coordinated.
Yeah,
But
big
anyone can allow.
anyone can be allowed to be a mediator. But if the most predominant in the court annex mediation, it's a retired judge or a lawyer who sits as a mediator. Unlike institutional mediation or private mediation, where even a non-practicing lawyer or a non-lawyer or a subject expert can sit as a mediator, right? And do you think lawyers make good mediators or lawyers make good counsels in arbitration?
Maybe.
Come again? No, I'm just right.
Ask
Ask you the question. Do you think, because most of us are
Lawyers
lawyers,
cannot be a good mediator.
do you think we can all become good mediators?
All, no, not all, maybe. Several lawyers.
But why do you think so? Lawyer cannot be a mediator.
That of the capacity of dissenting. Lawyers mostly are seen out of capacity to listen the problem of the party.
But in the court, if you don't present to your opponent lawyer, then you lose your case.
Yeah,
So do you mean to say that most of the lawyers lose the case?
because he is usually habitual to speak, to present their legal logic to the court.
No, but I feel they appoint those lawyers as mediators.
No. Parties cannot appoint both lawyers. So my next question is, if you think that lawyers cannot make good mediators, then why have you wasted 5 days with your precious time here?
Trying to be good, not a good answer, but trying to be good.
No, in my opinion, lawyers can make good mediators because a lawyer should be a. No, I'm not talking about that. Let's not talk about the financial. No, I know. Even in India, not many of us are practicing mediation because there's no money. Yeah. Even I, given an opportunity whether I sit as a sole arbitrator or I sit as a mediator, I go as a sole arbitrator. Because I get more money there than, and I get my respect there because there I'm going to pass an order, and here I'm only a facilitator. I'm at the mercy of them. But here I have power. In arbitration, I have power. So usually, in my opinion, lawyers can also make good mediators because if you look at the role of a mediator, the lawyer is the mediator is a conveyor. So he convenes the meetings. Lawyer is good in conveying the meetings with his clients. And I do not agree that lawyers are not good listeners. Lawyers are also good listeners. When the client comes to them, they allow the client to talk. Because the more the client talks, the more the clock ticks, the more he ceases. So he is also a good listener. Yeah. also lawyers can do fact finding, they can do analysis. In any given point of circumstances, they do that. And lawyers can also generate various options. Given a case, they can have multiple options to win and a multiple options to lose. So lawyers can be good mediators also, in my opinion. And that's it. We are all here. No, the very fundamental thing that you are the 50th batch itself speaks that lawyers are all 50th. All 49 batches are predominantly lawyers and agents are predominantly. So you are setting a benchmark at the 50th batch of BIMS training. Mediators. Training. Let's say, it's 50-50, not 1. 50. It's 50th batch. And any clarifications that you want to ask or any questions? Not only what we have thought in the last 3 days, anything other than that, or you want to share your experiences?
But when you ask the question, it's very difficult for us. Yeah, but it's sitting at your address. So we are also discussing in the during that we understand everything that
Language problem.
no, not the language problem.
There will be 75 questions, 70 multiple choice, and 5 questions will be true or false, and you will be given 60 minutes to fill up the PF slot, and you can write your name on the top, so that once you evaluate it, we also know. Yeah. It's only 6 months. Only at consultants, not for. I would request you to can you take it seriously, because I do not know what the board has decided, whether your certificate differs from the marks that you get or not. So take it seriously. Tell you very much. I have not. Huh? No, see, here I'm standing as a. And the whole thing was, I was the board. I have to maintain my confidentiality class. The maximum you get into the master. 75 will be the master. And then any negative marking. Yeah. 70 seconds. No. It's
Second.
No. We have left it out in other files because we have not have an advanced training. When you go for an advanced training, as per the IMI, there is a requirement for role play, or there is a requirement for Bible. So for that reason, it will take a couple of months to draft the syllabus and approve advanced. Still we have about 30 minutes. Let's go back to the exercise Ian has given. Vatna and so far. So she had asked you to write for me. Have you submitted to her already? No. You are. All there. They are taking front of you. And anyone say why mediation process? Dispute alternate of the
Saving the entity.
backlog of and in Nepal, do you have any landmark judgment on mediation? No, not that. So far, no, because your act has come into effect in 2011. So far, there is no landmark judgment. Yeah. Yes. No. And in Bangladesh, do you have any judgment on mediation?
Sir, it's the idea. Because
Because Nepal has no.
Sir, I think one of our national that instructed about 10 years.
You're enacted the law. You're not a senior. I this
I think that for in Nepal that is the historic one thing. Then about 10 years in certain we had there is a Maoist and the government and that is all concluded with a mediation. That after that peace accord.
Then no case. I think one you to experience landmark. Commercial.
I'm going just to
In that case, you enacted the law only recently, which is come into force in 2020. But even before we enacted the law, we have landmark judgment. Based on the civil procedure, the judges had referred 89, section 89 of CPC, the judges have referred the cases for mediation. And one is Justice Dhaka May, one of the landmark cases, one of the landmark cases. She had used CPC orders, order 20 or something, to refer to mediation. And Justice Joseph Puri has many landmark judgments of mediation. We have many landmark judgments. The first landmark judgment was in 2010. 2010 by Mumbai High Court. They referred it for mediation. In spite, there is no class of arbitration of mediation in the contract. Even there is no class of arbitration, reference to arbitration. If there is a dispute, the dispute will be amicably settled by the parties. And the parties fail, it will be referred to the chief executives circle. If the chief executives fail, it will be settled by the court of law. So there is no arbitration class, but in 2010, the judges took a stand. No, this has to go for mediation, and it has to go for arbitration. If mediation fails, arbitration. So we have landmark judgment. In this case, yeah, from 2010. Yeah. Then we have judgments being passed. And then Nepal, I mean, this is out of all of syllabus, just for man. Yeah. This mediation. Mediation for commercial contract. So there are more mediators.
Yeah.
And arbitration, do you have any time limit? With this time you complete arbitration.
Yeah, of course, there is time limit, but not working well or the time limit. Exceeding time limit sometimes and more.
So because in India, the Arbitration and Conciliation Act says you have to complete the arbitration within 12 months.
Yeah.
From the date of appointment of arbitration. And if you cannot complete in 12 months, then you have to go to the High Court to get it extended by 6 months. So normally the arbitrators don't do that, don't allow the parties to go to the court to get it extension for another 6 months. Because that will speak volume over them. So you don't, and in Bangladesh, do you have any time limit for arbitration? Oh, no. Is there? And what is the maximum time an arbitrator? And the arbitration awards, is it automatically enforceable or is it enforceable by the court?
Enforceable by the court.
You have to go to the court. Does the court set aside any arbitration awards?
Yeah.
In what circumstance?
Public policy.
Public policy.
Public
Public policy. And in case the arbitrator fires for the code of arbitration. There is a code of arbitration. And international arbitration orders are also in.
Yeah. But not the award from India.
No, because you don't have a thing.
Yeah. Because India has not accepted reciprocal provision. Indian award is not enforceable in Nepal, and Nepali award is also not enforceable in India.
But if you seat of arbitration in Singapore, then if you have a dispute with the Indian firm, And you both have a seat of arbitration in Singapore. Yeah?
Now we are making, we have a Asia Pacific Center for Arbitration and Mediation. They can. We are trying to refer to FCAM.
So to summarize, MCQ 7 questions, 70 multiple choice, 5 true and false, it will be for 1 hour between 2 o'clock to 3 o'clock. So your lunch break is curtailed by half an hour. You try to close it by 1 o'clock so that your lunch break you have for 1 hour. So you don't compromise on your lunch break. And then you will also have some time to breathe, some time to go through your notes. Yeah. Yeah. Yeah, and I wish you all the very best. And time performance will meet again. Thank you very much. Thank you.
Record.